webinar. Today, we'll be talking about the rollback of civil and political liberties at the hands of India's Supreme Court, no less, in recent months. Of late, many jurists, legal luminaries, and human rights defenders in India have expressed their deep disappointment with several of the court's rulings. Prominent among them is the Supreme Court's decision in June to bring closure to the victims of the 2002 Gujarat pogroms under Narendra Modi, who was then the state's chief minister, by dismissing a petition from a riot widow to investigate Modi's role in that violence and hold him accountable for it. Shockingly, the Supreme Court not only accepted the police version of Modi's story that he was not involved in the violence, but the judges also ordered investigation against one of India's best-known human rights defenders, Tista, Setovad, who was promptly arrested within hours. Then in July, the Supreme Court summarily dismissed a petition seeking investigation into the massacre of 16 men, women, and children in Chhattisgarh state in 2009. The petition claimed that these were extrajudicial killings by Indian security forces. Once again, the Supreme Court accepted the police version and even slapped a fine of ₹500,000 on human rights defender Himanshu Kumar. Just as with Tista, the courts also ordered the state to investigate Kumar's role in filing the petition, making him look like a criminal merely for asking for justice. Himanshu has courageously refused to pay the fine and is willing to go to prison for his rights. Throughout this year, we have seen the Supreme Court delay what should have been the urgent hearing of Karnataka Muslim students' petition to overturn the High Court's verdict to ban hijab in schools. And we have seen the court condemn the blasphemous comments of former BJP spokesperson Nupur Sharma, but order no police action against her, despite the fact that her anti-Muslim remarks sparked protests across India. Joining us today are several law experts and human rights defenders who will be shedding more light onto the subject. But first, we'd like to play this week's news roundup from India.
India's Home Minister Amit Shah said the federal government will next year begin implementing a controversial Islamophobic law that has been globally criticized for its potential to end its citizenship of the country's 200 million Muslims. Thousands of Muslims have been in prison for opposing the law since 2019. Mockery of justice. The High Court in Uttar Pradesh state denied bail to Muslim journalist Siddique Kappan, who was arrested in 2020 while on his way to cover the rape and murder of a Dalit woman. The United States Commission for International Religious Freedom has called Kappan a victim of freedom of religion and belief. A mob of Hindu extremists armed with sticks and rods lynched a 50-year-old Muslim man, Nazir Ahmed, to death in Madhya Pradesh while he transported cows to sell at a fair. The mob falsely accused him of taking the animals for slaughter, which is banned. While failing to arrest the murderers, the police filed charges against the dead man. At another Islamophobic act, officials in Assam state demolished an Islamic seminary after arresting its manager Mufti Mustafa, falsely accusing him of involvement in terrorist activities. Assam's chief minister Himanta Biswa Sharma, who is overtly Islamophobic, said his government has shut down 800 Islamic seminaries. Officials and police demolished the famed Masjid Khaja Mahmood in Hyderabad, making it the sixth mosque in Telangana state to be demolished since Chief Minister K. Chandrasekhar Rao took power in 2014. Federal Muslim lawmaker Asaduddin Owaisi's party leader announced it would build another mosque at the same site. After two Muslims and a Hindu were killed in religious violence in Karnataka state, Mahesh Shetty Timarodi, a former leader of the violent Hindu supremacist group the Vishwa Hindu Parishad, blamed his former organization for starting the cycle of violence. The VHP is linked to Prime Minister Narendra Modi's Bharatiya Janata Party. Police in Karnataka state arrested 6 Hindu men for the brutal lynching of a 23-year-old Muslim, Muhammad Fazil, who was hacked to death in July. Police said their leader, Suhas Shetty, had a history of anti-Muslim violence, including murder. Shetty had attended events by the VHP and Bajrang Dal, another BJP-linked militant group. Uttar Pradesh police filed criminal charges against officials at a school in Kanpur city for including Islamic scriptures in its multi-faith prayer. Hindu supremacists then sprinkled holy water at the school to purify it. In Delhi, another school canceled a field visit of preschoolers to a mosque after Hindu extremists threatened violence.
तो हम अगर पर्टिकुलर किसी एक धर्म को लेकर चल रहे होते या पर्टिकुलर किसी दो धर्मों को लेकर चल रहे होते तो विवाद होता, हमें समझ आता। हम चारों चीजें इक्वली लेकर चल रहे हैं।
That was this week's news roundup from India. Let's now turn it over to our panelists, beginning with Prashant Bhushan, easily India's best-known legal luminary and human rights defender. Mr. Bhushan has decades of experience of legal and civil rights work behind him. Many a time he has been in the crosshairs of India's top judiciary for openly calling it out for its arbitrariness and even corruption. 2 years ago, the Supreme Court ordered him to pay a fine, and it was widely believed that he may be sent to prison. But evidently, better counsel prevailed in the Supreme Court, and they did not proceed against him. Mr. Bhushan has been the attorney in some of the most important civil rights cases before India's judiciary. Without much ado, let's hear from him.
Sorry.
Unmute. Prashant needs to unmute himself.
Yeah. Thank you, Safa. Good evening to everybody. Good afternoon, good evening, good morning, whatever time it is there. On the Supreme Court's recent rollback of civil liberties, or rather its assault on civil liberties, one needs to understand that the Supreme Court is charged with a very, very important responsibility to protect fundamental rights, human rights of the citizens, as well as non-citizens who are in India, such as Rohingya refugees, etc. And quite apart from that, it is also supposed to ensure that the executive and the legislature function within the norms or within the bounds of their powers. In the recent years, since the Narendra Modi government has come to power, we have been seeing a sort of rampant trampling of rights of people. There is, of course, a full-blooded assault on minorities in this country. There are lynch mobs out on the streets. There are lynch mobs on the social media. Laws are being made to somehow reduce them to second-class citizens. All kinds of things are being done. There are fake encounters being done of Muslims. There are houses of Muslims being demolished just because they are protesting. But apart from that, we have been seeing an assault on the civil liberties of any dissenter, anybody who stands up and speaks out against this government, especially journalists or activists, etc. A very large number of our activists and journalists are in jail. Some of our finest human rights activists have been arrested in the Bhima Koregaon case. Many of them were also arrested in the Delhi riots case. Many others are charged with sedition, like Siddiq Kappan, etc., or charged under UAPA and are being kept in prison for years altogether and are being denied bail. So in such a situation, the role of the Supreme Court and the high courts, the higher judiciary in India, becomes even greater because it is really their responsibility and their power. It is their power, their duty, their responsibility to protect the rights of people whose rights are being trampled. There are many people in Kashmir who have been in jail. The Article 370 was sort of virtually removed. Kashmir was converted into 3 union territories. All those acts have been challenged in the Supreme Court. Many people are in jail. Habeas corpus petitions were filed on their behalf. But we find that all these petitions, the Citizenship Amendment Act, which is clearly discriminatory against Muslims because it leaves out Muslims as one conspicuous religious group which will not be given citizenship under the Citizenship Amendment Act, even if they are refugees. So therefore, all kinds of violations of human rights are taking place, and we are seeing that many cases which are taken to court for challenging those state actions, whether it is state actions by way of falsely imprisoning people on bogus charges of sedition, etc., or under UAPA, or even under the Penal Code, or under the National Security Act, which allows preventive detention. Those cases are not being heard. The challenge to the Citizenship Amendment Act is not being heard. The challenge to the change of status of Kashmir has not been heard. So this is one way in which the Supreme Court has been virtually abdicating its role as the guardian of civil liberties and human rights of the people in India. Then we find that that even when cases are heard, in many cases, for example, when the Bhima Koregaon case came before the Supreme Court, of course, there was a 2-to-1 judgment where the imprisonment of these activists was initially challenged. In that case, again, the Supreme Court dismissed that challenge. And I mean, it's a clearly false case against these people. Several forensic experts have shown that the material on the basis of which they are charged has been planted in their computer. But now it's been almost 4 years and these people are still in jail. Some of the finest human rights activists in the country. So in many cases, in Siddiq Kappan's case, of course, that case has not yet been decided by the Supreme Court, but the High Court has denied him bail. In many cases, bail has been denied by the High Courts or even sometimes by the Supreme Court. So that is another way in which the Supreme Court has been abdicating its responsibility. That is by denying bail in obvious cases where clearly the charge is bogus. And one way in which courts are doing this is because of the Supreme Court's absolutely faulty interpretation or upholding the draconian provisions of bail in the Unlawful Activities Prevention Act, where the normal principle of bail, which is that bail is the rule, jail is the exception, and bail can only be denied if one of the three things are present. That is, there are reasonable grounds to believe that the person will flee trial, he will not be available for trial, will flee from justice. 2, that there are reasonable grounds to believe that he or she will tamper with evidence. And 3, that he has committed a heinous offense, and if released on bail, he is likely to repeat those offenses. Unless one of these 3 conditions are present, bail is the rule. But unfortunately, under UAPA and under the PMLA, Prevention of Money Laundering Act, the burden of proof has been reversed. So here, at least for bail, it is provided that the person who is accused has to prove his innocence in order to get bail. Now, it is impossible before trial, virtually impossible before trial, for anybody to prove his innocence before even the trial begins. And further to compound the problem, the Supreme Court in Vatali's case, that is a judgment decided by the same infamous judge who recently retired and who gave the judgments in the Zakia Jafri case of Gujarat, in the Himanshu Kumar case of Chhattisgarh, as well as in this PMLA case. That same judge, that is the one who recently retired from Maharashtra, that same judge decided that at the stage of consideration of bail under UAPA, even the admissibility of evidence which is adduced against the accused person by the police or the security agencies will not be gone into by the courts. And it will be assumed that any evidence that has been adduced is admissible. Similarly, in the PMLA case, they have virtually reversed the burden of proof and further held that even a formal FIR is not necessary before the Enforcement Directorate can arrest people under the Prevention of Money Laundering Act. So that draconian act has been made even more draconian by this sort of baleful interpretation to the act given by the Supreme Court. But what has happened recently in the Zakia Jafri case or in the Himanshu Kumar case is absolutely shocking. Not just in these two cases, but what happened earlier in that Harin Pandya murder case. See, in the Harin Pandya murder case, the police had, the Gujarat police had charged some Muslims. The High Court gave a scathing judgment while acquitting all those people, saying that the police had completely botched up the investigation. Thereafter, we filed a petition in the Supreme Court that the case needs to be reinvestigated in the light of the facts revealed by the High Court, pointing out that it is impossible for Harin Pandya to have been murdered in the way in which the police was claiming, because he would need to be shot from below while sitting in a car, which is impossible. If he's sitting in a car, it is impossible for him to be shot from below. So therefore, there were many other facts and circumstances which clearly showed that the Gujarat police investigation was totally bogus. They had falsely implicated the wrong people, and the real people behind his murder had not been caught. So we went to the Supreme Court. The Center for Public Interest Litigation went to the Supreme Court with all this evidence, some things which were written in the High Court judgment, plus many other things which we had got hold of. And the Supreme Court not only dismissed our petition, but imposed costs upon us, and then went on to reverse the High Court judgment in an absolutely convoluted judgment. That judgment was given by Justice Arun Mishra, who was another infamous judge who immediately or soon after retirement was made the chairman of the National Human Rights Commission. Was allowed to retain his official bungalow for 9 months, totally in violation of the rules, and thereafter made the chairman of the Human Rights Commission. Now, Justice Khanvilkar, who has delivered these other 3 judgments, including Zakia Jafri, Himanshu Kumar, PMLA, and he had delivered the Batali judgment. He is just retired. We don't know what post he will be given. There are many posts which are vacant. The chairmanship of the Law Commission, the Lokpal's post is also vacant. Let us see what post he is given. But we have seen from experience that these kind of judges who always side with the government, especially in judgments before their retirement, are usually given some post-retirement jobs. Just like Justice Ranjan Gogoi, the Chief Justice, who had delivered that Ayodhya judgment, who also delivered that Rafael judgment just before retirement, and soon after retirement, he was made a member of the Rajya Sabha. But these judgments of Zakia Jafri and Himanshu Kumar sort of go beyond the pale altogether, where they have virtually, in Zakia Jafri, the Supreme Court has said that this Tista Setovad orchestrated a false case or a false charge against the Gujarat government. They say that she had the temerity to question all the high-ups in the Gujarat government. And she orchestrated a false case against the Gujarat government, and therefore she needs to be put in the dock. And using that judgment, the Gujarat police has arrested her, and she remains in jail. Now, there were any number of facts and circumstances which showed that which indicated that there was complicity of the higher ups and the chief minister and other ministers and senior people in the Gujarat administration in the riots. There was the NHRC report itself, when Justice Verma was the chairman of NHRC. The NHRC itself had petitioned the Supreme Court for transferring all these Gujarat riot trials outside Gujarat. One of the ministers of the Gujarat government had been convicted for these riots, etc. The Supreme Court itself had formed an SIT to reinvestigate the Gujarat matters. The Supreme Court had also transferred the trials. The Supreme Court had earlier in a judgment also castigated Mr. Modi by saying that these modern day Neros fiddled while Gujarat was burning. The amicus curiae appointed by the Supreme Court had also questioned the SIT's investigation, which is what Zakia Jafri and Tista Setovad were questioning. And despite the fact that the Supreme Court did not even accept Tista to be a petitioner in this case, they have virtually indicted her and said that she should be put in the dock, and these activists in air-conditioned rooms sit and have the temerity to make these charges against people in high places, and therefore she should be put in the dock. And because of that, the Gujarat police has arrested her. So, I mean, this takes the assault of the Supreme Court, its abdication of their duty, or the assault on civil liberties by the Supreme Court to a different level, where a person who has come to the Supreme Court, petitioned the Supreme Court that please investigate this matter, is now being penalized for having approached the Supreme Court. And the same thing they have done in Himanshu Kumar's case. There was enough evidence to suggest that these encounters were done of adivasis had been killed in these killings in Gompad, and there was enough evidence to suggest that the killings had been done by the police and the security forces. So many tribals had themselves come to the Supreme Court who were eyewitnesses to the killings and who had sworn on affidavit that these people had been killed, that their relatives had been killed by the security forces and the police, by the local police, etc. And yet the Supreme Court just totally relies on the police version or the police investigation in that case and says that these people should be, that Himanshu Kumar should be penalized 5 lakhs for having brought a false case to the Supreme Court. So it's really something beyond bizarre that the Supreme Court has done in at least these 2-3 cases. That is, penalizing the petitioner herself or himself for having approached the Supreme Court, when of course there was more than enough evidence to justify an independent investigation into these killings, into the Gujarat riots, as well as into the killings of these tribals in Chhattisgarh. But yet they have not only dismissed that plea, which in my view was totally wrong to dismiss it without ordering a independent investigation, but more than that, by penalizing the petitioners. So it's really very unfortunate that the Supreme Court has gone to these lengths in order to really assault the civil liberties of citizens, including petitioners who approach the Supreme Court. So, all in all, of course, I'm not saying that everything that the Supreme Court has been doing is bad in the recent past. There are some good judgments also. For example, recently Mohammed Zubair was released on bail, and the Supreme Court gave a good judgment, again reiterating the basic principles of bail and also pointing out that the authorities and the police authorities are being trigger happy in arresting people for no good reason at all when there is no justification for their arrest. Similarly, in a few other cases, in the Pegasus case, they gave a good order ordering an independent investigation, but after that there has been no follow-up of that. Similarly, in the case of that Ajay Mishra Taini and his son, who mowed down several farmers in his jeep, his bail has been virtually cancelled by the Supreme Court. So, so there are a few good judgments, but those judgments kind of stand out as exceptions. And we are seeing that in general, the Supreme Court has, by and large, abdicated its responsibility to protect the human rights and fundamental rights of citizens, and indeed gone further in some cases to even assault the civil liberties of the citizens. And as I said, one of the reasons for this is this lure of post-retirement jobs, but there are all kinds of reasons why the Supreme Court is behaving in the way that it is. We are seeing that the independence of the Supreme Court is today seriously under question. Seriously under question. Recently, Mr. Sibal said that he had lost faith in the Supreme Court, and that's the feeling of a large number of citizens in this country. But I still feel that we should not completely lose hope in the Supreme Court. There are still a large number of honest and upright judges, and we need to give them strength. And the way to give them strength is that when they do something which is right, which we see as being correct and by way of protecting civil liberties and human rights, etc., we should applaud them. And when they do something wrong, we should criticize them and criticize them strongly. That way, the good judges who want to stand up but who may be feeling weak right now or isolated right now will get the strength and the courage to stand up. And those who are kind of becoming or have become virtually the rubber stamps of the government, they will be deterred from behaving in the way in which they have been behaving. So those are just a few things that I wanted to say on this subject. Thank you very much.
Thank you so much, Mr. Bhushan, for your brilliant remarks. We truly appreciate you taking the time to be here and share your thoughts with us today. One of the strongest criticisms of the Supreme Court has come from, as Mr. Bhushan mentioned, from Kapil Sibal, a former federal law minister and one of India's most prominent lawyers who has practiced at the Supreme Court for 50 years. Speaking at a People's Tribunal in New Delhi last weekend, Sibal candidly called out the Supreme Court by saying there's no hope left from it. And I'd like to play that video for you now. Let's take.
इस साल मुझे 50 साल हो जाएंगे सुप्रीम कोर्ट में वकालत करते करते, और 50 साल के बाद मुझे ऐसा लगता है कि मुझे इस संस्था से कोई उम्मीद नहीं है। आप बड़ी बड़ी अदालत की जजमेंट्स की बात करते हैं, लेकिन ज़मीन पे क्या हो रहा है उसको आप देखिए, उसमें बहुत भारी अंतर है। अदालत कुछ कहती है, ज़मीन पे कुछ और हो रहा होता है। आपने कहा कि सुप्रीम कोर्ट ने बड़ी बड़ी अच्छी प्रोग्रेसिव जजमेंट्स दी, तो मुझे ये बताइए कि जजमेंट्स के बाद ज़मीन पे क्या हो रहा है। और जो भी धर्म संसद हो रहे थे, जो भी बड़े बड़े भाषण दिए जा रहे थे, और ऐसे भाषण जो सुनकर आदमी सोचता है कि हम किस समाज में रह रहे हैं। तो जब वो भाषण हमने सुप्रीम कोर्ट के सामने रखे तो सुप्रीम कोर्ट ने क्या किया? कुछ कदम उठाए? किसी की गिरफ्तारी हुई? अगर हुई तो एक ही दिन में बेल हो गई या 2 दिन में बेल हो गई। जाकिया के केस जब मैंने आर्ग्यू किया 1 महीना चला। और ताज्जुब की बात यह है कि जब हमने याचिका अपील डाली तो मैंने कहा कि हम कोई दस्तावेज कोर्ट के सामने नहीं रखेंगे जो किसी प्राइवेट पार्टी का दस्तावेज हो, कोई प्राइवेट डॉक्यूमेंट हो। हम केवल वही डॉक्यूमेंट कोर्ट के सामने रखेंगे जो सरकारी डॉक्यूमेंट हो, सरकारी दस्तावेज हो, ताकि कोर्ट हमें ना कह सके कि आप अपनी बात अदालत के सामने रख रहे हो। हमें उनको कहा कि ये तो ऑफिशियल पेपर है, ये सरकारी दस्तावेज है, ये सरकारी दस्तावेज ये कहानी बताते हैं, तो आप इस पे फैसला कीजिए। एक उदाहरण देता हूं कि आपको मालूम है कि गुजरात के समय गुलबर्ग सोसाइटी ही नहीं, कई जगह पे लोग जलाए गए, मकान जलाए गए। तो उस समय नेचुरली वहाँ फायर ब्रिगेड भी होती थी। तो जो इंटेलिजेंस एजेंसीज थी वो फायर ब्रिगेड में फ़ोन करती थी कि साहब यहाँ आग लगी हुई, आके बुझाइए। तो वो जो डॉक्यूमेंटेशन थी, कॉरेस्पॉन्डेंस थी, वो इंटेलिजेंस की कॉरेस्पॉन्डेंस हमारे सामने थी। तो ताज्जुब की बात यह है कि किसी फायर ब्रिगेड ने फ़ोन नहीं उठाया, किसी फायर ब्रिगेड ने फ़ोन नहीं उठाया। तो हमने बहस की कोर्ट के सामने कि ये बताइए साहब कि जो एसआईटी आपने बनाई थी, सुप्रीम कोर्ट ने बनाई थी, उस एसआईटी ने जाके पूछा कि भैया आपने फ़ोन क्यों नहीं उठाया? तो मैं ज़्यादा नहीं कुछ कहना चाहता, तो सिफारिश दी गई, ये दी गई कि वो बिजी होंगे। जिस कोर्ट में जज बैठाए जाते हैं थ्रू अ प्रोसेस ऑफ कॉम्प्रोमाइज, जिस कोर्ट में कोई सिस्टम नहीं है कि कौन सा कोर्ट किसकी अदालत पे लगेगा, जिसमें चीफ जस्टिस ऑफ इंडिया तय करता है कि ये मैटर किसके साथ जाएगा और कब जाएगा, कब सुनवाई होगी, कोई सिस्टम नहीं है, वो कोर्ट कभी इंडिपेंडेंट हो ही नहीं सकती। असलियत तो ये है कि जो भी सेंसिटिव मामले होते हैं जिसमें हमें मालूम है कि प्रॉब्लम है, वो गिने चुने जजेस के सामने लगता है। हम कोर्ट में पेश होते हैं तो हमें मालूम है कि क्या नतीजा होने वाला है। और अब सबसे खतरनाक इन्फोर्समेंट डायरेक्टर है देश में, उसने तो इंडिविजुअल लिबर्टी की सीमाएं पार कर दी। जब तीस्ता का मैटर सामने आया तो तीस्ता के बारे में तो कोई बहस ही नहीं हुई। इनफैक्ट मुझे कहा गया कि आप इसमें मत पढ़िए, हमें क्या लेना देना है इस मैटर के साथ। तीस्ता के खिलाफ उन्होंने बहुत सब कुछ कह दिया, आप जानते हैं। आज तीस्ता जेल में बैठे हुए।
That was senior advocate for the Supreme Court, Kapil Sibal. Our next speaker now is Mr. Himanshu Kumar, who is a renowned Gandhian activist who in July 2022 was falsely accused by the Supreme Court judges of forging evidence that the police had carried out the torture and killings of adivasis, also known as the indigenous people of India, in Chhattisgarh state. Kumar has refused to pay a fine of 500,000 Indian rupees that the court has imposed upon him, and has stated that he is ready to go to prison over it. We are very honored to have him here with us. Mr. Kumar, thank you for joining us. Please go ahead. If you could unmute yourself, please.
Okay.
Now we can hear you.
Thank you. Yeah. In 1992, me and my wife went to Chhattisgarh to serve Adivasi people there. We started living under a tree. Then, with the help of local community Adivasis, we made a place which we used to call ashram, and we started serving Adivasis there, programs aiming at their health, community health, education, livelihood, the watershed development, and on other issues. In 2005, Chhattisgarh government started an armed militia, organized an armed militia, and started getting villages vacated through this armed militia. This operation they called Salwa Judu. Later, Supreme Court of India declared it anti-constitutional and ordered to stop it. In this operation, this Salwa Judu, 644 villages were burned down, thousands of Adivasis were killed, thousands of Adivasi women were raped by security forces, and we took these cases to different courts, local court, high court, and Supreme Court. Supreme Court also ordered that these villages should be rehabilitated, Adivasis should be compensated, and FIR should be lodged against police officers. But Chhattisgarh government did not follow any of the Supreme Court orders. We started rehabilitating villages at our own. And in 2009, this Gompar massacre happened. Gompar people came to us and told us about whatever they experienced. We asked other human rights organizations, and we organized a fact-finding team. We went there, we sat with the villagers, and then we took villagers to Delhi with us. There, a big meeting was organized at Constitution Club, Delhi, where these Adivasis, the survivors and the family members of the people who were killed. And next day, we filed a petition, these Adivasis, along with these Adivasis. In 2010, government said that Himanshu Kumar is a Naxal sympathizer. That's why this petition is being filed. Then Supreme Court rejected government's plea and said that to stop creating this bogey of Naxal sympathizers. In 2017, again, state government said that Himanshu Kumar should be fined because this petition is false. Then again, Supreme Court did not listen to them. Now in 2022, again, central government has said that Himanshu Kumar is a Naxal sympathizer, and that Supreme Court should authorize central government, NIA or CBI or any other central agency to file an FIR against Himanshu Kumar and investigate his links with Maoists, and he should be investigated upon and be penalized. And this time, Supreme Court accepted it and gave an order accepting government's prayer. And not only this, but also that anyone who files a case against the atrocities of security forces should be investigated upon and be put in jail. So now raising voice against atrocities of security forces by default has become an criminal act after this judgment. So Supreme Court, this judgment has actually put an act on the fundamental right of the Adivasis, the human rights of the Adivasis. Now, no one can raise any issue and go to the court for protection of human rights of the Adivasis. So this judgment will not affect only me and put me in jail, but also everyone who is raising human rights issues in this country will now be put in jail.
Thank you so much, Mr. Kumar, for joining us today. I assure you that we in the global diaspora applaud you for your courage, for all the work you have been doing for the preservation of human rights in India. We also pray for your well-being, and we hope that you remain safe. So thank you for joining us today. I'd like to turn now to yet another top Supreme Court lawyer, Prashant Bhushan, a senior advocate and former president of the Supreme Court Bar Association, who has offered a stinging criticism of the Supreme Court. In the video I'm about to play, he speaks on the court's handling of the case of Tista Setovad and Arbi Srikumar. Let's hear from him now.
Supreme Court has really crossed all lines, all limitations, and all sense of propriety in ordering prosecution. And I think it is, I feel terribly sorry that the lady, I may or may not agree with what she was doing. But the fact is that it is very sad to see for us lawyers that an innocent citizen has been, and what is this charge that Gujarat was defamed? I mean, no state can be defamed by an individual. I mean, all that she did, after all, Muslims are also citizens of this country. And if one section of citizens were discriminated against by the state, then, I mean, we have every right to come to their help. And nobody can be, I have appeared in large number of cases. I am appearing in demolition case tomorrow only. So, I mean, somebody will suggest that we should all be taken to task. I mean, I don't think Supreme Court has done service to itself. Rather, it has done great disservice to itself by passing these orders. And I hope and pray that some sense prevails in both the executive and the judiciary, and Mr. Setovad and Mr. Srikumar are released as quickly as possible. Every day's detention, to my mind, is unconstitutional, and it sends, I think, very, very wrong message. You have taken away liberty without due process of law.
Those are very strong comments from Mr. Dave. I'd like to turn now to our final panelist, who is Mr. Mihir Desai, a veteran lawyer in Mumbai who has long defended human rights defenders and members of marginalized communities such as Muslims and Dalits falsely charged with crimes. He was also the lawyer for prisoner of conscience Tista Setovad, who was accused without evidence by the Supreme Court of forging evidence to prove that Mr. Modi was complicit in the anti-Muslim violence in Gujarat in 2002. Mr. Desai, thank you so much for joining us.
Thank you. Thank you very much for inviting me here. I think both Prashant and Himanshu have covered a lot of ground, but I would just like to reiterate a few things. What we are passing through in India right now is hollowing out of the democracy. You have a semi-fascistic kind of a state which has emerged. And you have, look at the kind of, and there is a massive Islamophobia which is being generated. Look at the kind of laws which the present government has been passing. First, you have the Citizenship Amendment Act, by which accepting Muslims, anybody else from any other religion, walking into India from the neighboring states will be given citizenship, but not Muslims. Yeah? That is the Citizenship Amendment Act. You have similarly so-called freedom of religion acts, which are basically anti-conversion laws. You also have what are known as the beef ban laws, which is essentially, preventing people from eating beef. So you have a whole range of laws, okay, which target the Muslim community either directly or indirectly. Okay, and in any event, these laws are used at the ground level to target the minority communities, whether they be Muslims, they may be Christians, it may be anybody. In this context, it becomes very important for the Supreme Court, which has over the last 50 years played a stellar role in ensuring that the state doesn't cross its limits. Okay? It becomes important for Supreme Court to ensure that the state stays within its limits, and these kind of laws are not allowed to be implemented. Now, please remember one thing, that the Indian Supreme Court is a very, very powerful Supreme Court. Okay, very powerful in the sense that it has a jurisdiction to strike down not only laws, but also to strike down constitutional amendments. Okay, it has jurisdiction to set up committees, send rapporteurs, take suo motu action. It has wide powers, and it has been using these wide powers to expand fundamental rights, etc., over the past decades. Unfortunately, what has happened in the last couple of years in the Supreme Court is, as the state has been moving towards crushing any kind of dissent. Okay, because the present state does not tolerate any dissent. Okay? So you have, for instance, the Article 370 of the Constitution, which gives special status to Kashmir, Jammu and Kashmir, being abrogated by the government. Okay, that abrogation is challenged in the Supreme Court. Now, the challenge may be upheld, may be denied, whatever it is. But the Supreme Court just is not hearing the matter in the last 3 years, 4 years. Okay? It is refused to, it just doesn't hear this matter. What happens at the end of it is the whole case will become infructuous. Because whatever has to be done, I mean, the special status entitles Kashmiris to have their own property, not allow anybody from outside buying of property, things like that, which are there in Jammu and Kashmir. Now, by the time the Supreme Court hears the matter, all this will become infructuous. Okay? Similarly, the CA-NRC, that is the Citizenship Amendment Act, which I talked about, okay, that came in 2019 till now. Okay. And it was challenged in 2000 and very next day. Till now, the Supreme Court has not heard it. And now, as you saw in one of the clippings, the Home Minister is saying we are going to implement it from next year. It would have been implemented earlier, in fact, if COVID had not intervened. So that's a second. Similarly, okay, there is a huge controversy about what is known as political bonds. Okay, where and the other thing is the PM Care Fund. PM Care Fund is set up by the Prime Minister, where billions of rupees are poured in, and it's supposed to be completely non-transparent. Nobody knows what money is being poured in there for. It's not supposed to be, I mean, you can't access those accounts. They are not supposed to disclose anything. But all these things are challenged. Political bonds are bonds which are purchased by corporate houses from the government. Again, nobody is told which corporate houses bought how much, how many bonds, and those bonds are then given to a political party. That is challenged. None of this is being looked at by the courts, and these are very, very important matters. Hijab case, which you yourself talked about earlier, has not been. I mean, the Supreme Court is not hearing that matter. Okay, so you have so at one level you have a situation whereby Supreme Court is not hearing the matter. At another, hearing some of the most important matters. At another level, you have a situation whereby any state action. Okay, any action of the state or any legislation of the state, okay, which gives extraordinary emergent powers to the state, is being justified by the courts. Okay, whether it be, as Prashant was mentioning, whether it is the Prevention of Money Laundering Act, under which today every second citizen is likely to be targeted, okay, by claiming that you are involved in money laundering, and once you are put in jail, you won't be out for years together till the trial is over. Trial may or may not get over for 5, 10, 15 years. That's the kind of thing. Similarly, the so-called anti-terror law, okay. Again, a large number of people who are arrested under the anti-terror law are Muslims. Please remember that. Okay, a large number of people. Okay. Again, here, there doesn't have to be a terrorist act in order to arrest somebody. Just because you believe somebody is likely to commit a terrorist act, whether that person has ever seen a bomb in his life, okay, you can arrest and put that person behind for 10 years. Again, these kind of laws are being upheld by the Supreme Court, where you just cannot get bail for years together. These kind of laws are being upheld. And now, finally, what is happening, and that is what has happened in Tista, Setovad, or Himanshu Kumar's case. Finally, what is happening is that, as we are seeing, and it is not just in Himanshu or Tista's case, but in a number of other cases like the Bhima Koregaon case or the Delhi riots case, Siddiq Kapan's case, various other cases, the state is targeting any civil society activists who gives voice to the marginalized. Okay. So if you are representing the marginalized, if you are giving voice to the marginalized, you will be targeted, you will be put behind bars on some trumped up charge, and you will spend years in the jail without there being any kind of recourse to bail, etc., etc. So and this not only has an effect on the people who are arrested, but it has a very large chilling effect on the entire society. The other law which they use and which the Supreme Court has upheld is the FCRA, which is the Foreign Contribution Registration Act, which basically a lot of NGOs, the non-governmental organizations in India, do receive funds from donor agencies, because that's the only way they can continue to function, whatever they're doing. They have been clamped down upon. For instance, amnesty has virtually been thrown out, and amnesty people have been asked to pay fine of some 60 million rupees or something like that. Amnesty International. Similarly, Greenpeace was virtually thrown out. Okay? So any kind of dissent, okay, is being crushed, and people are resisting. The civil society is resisting. Tista, Setovad, Himanshu Kumar are resisting this. Okay, for Tista Setovad, for instance, from 2002. Okay, she has been working very, very courageously. Okay, in Gujarat, helping the riot victims. Okay, trying to ensure that they get proper rehabilitation, trying to ensure that they get justice in the court system, and it is because of her efforts that 125 rioters, okay, who could kill Muslims, who got life imprisonment. Okay, this is the reality of it. Now, when it is all right as long as you are fighting against the foot soldiers. People don't mind. Okay, you do a little bit of against some foot soldiers, somebody who comes and lights a fire here, lights a fire there. You pick them up, put them behind bars. Okay. Okay. But when it comes to the top executives, political or bureaucratic or police executive, okay, and that's what we were doing in Zakia Jafri case. We were saying that forget the foot soldiers. Foot soldiers are acting at the instructions of the top political executive, and you must hold them accountable. That is what we were saying, that you must investigate, you must put them on trial. We are not saying convict A, B, or C. We say at least put them on trial. There is enough evidence. There are 23,000 pages worth of evidence. At least put them on trial. And what happened was that, unfortunately, the Supreme Court rejected the case, which itself was wrong. But while rejecting the case, they effectively directed prosecution of people who are whistleblowers and who whistleblowers from within the police, okay, who came out with data saying that, look, yes, this is correct. The state government had, the state executive had ordered certain kind of draconian measures, So so the Supreme Court has basically directed prosecution, or its order judgment has resulted in prosecution and jailing of whistleblowers and civil society members. Same thing has happened in Himanshu Kumar's case. So, and again, as I was saying, that Tista and Himanshu Kumar are bold people. Okay, they will face up to this. They will not change their ideology. They will not change their politics. They will not change their activities because they are sent to jail. They will continue to fight. But imagine the kind of chilling effect it has on other people. Okay, people who are sensitive, people who want to do something for the society, people who do not like the direction in which the country is going. Okay? And those people, the amount, they get scared. They get and that's what the government wants. That you scare all these people, okay, into inactivity, into not dissenting, okay, into not questioning, not holding the government to accountability. Okay, that is what they want, and that is what they are seeking to achieve. But as you know, you have people like Himanshu, you have people like Tista, and you have various other people, of course, who are not going to cow down because of this this kind of threats. You know, unfortunately, what is happening is that the judiciary has played a very negative. I mean, judiciary should be there to protect the Himanshu Kumar, should be there to protect the tribals, should be there to protect the. I mean, nobody is disputing that thousands of people got killed in Gujarat in 2002. You should be there to protect them. You should be there to protect the Tistas who are trying to, with all adverse situation, fighting. Okay? You should be there for doing there for that purpose. Instead, the Supreme Court has reversed its role and is virtually rubber stamping all what the government has been doing. Okay, in terms of whether passing legislation, in terms of executive action, in terms of police action, security forces action, in terms of political action, it is unfortunately that is what has happened. Of course, we as lawyers know that the justice delivery system is part of the democratic process, and so we are not going to shy away from using it. We may or may not lose hope in it, but we are going to keep on knocking at its door. For more and more, in more and more cases, it's not that we are going to boycott the judiciary or something like that. We are going to, because it's it's my right to approach the Supreme Court. It's a constitutionally given right to approach the Supreme Court. Why should I give it up just because Supreme Court is not performing its duty? So we are going to continue to do that. And I think that's where I'll end. Thank you very much.
Thank you so much, Mr. Desai, for your powerful remarks. Thank you to all of our panelists for speaking on this very important topic today. I know we're running short on time, but I'd like to transition briefly into a Q&A session. For those of you who are watching, the chat box is open. You may drop in your questions if you have any. I think I'll go with one for now that is, I think all of you have touched upon, but hopefully we can expand on a little bit. Thousands of Muslims across India are in prison, and not just Muslims, but also from other marginalized communities such as Dalits and Adivasis are in prison on charges of sedition and terrorism. What hope can they have of justice? I open this up to any one of you to take the question.
Himanshu, you want to take it or should I respond?
Yeah, let us see who the question is targeted to.
It's targeted to either of us. So why don't you respond? Since you will have more familiarity, at least in near future, with prisons than I will.
No, you please stay.
Okay, fine. No, I will see. Remember one thing: that 2/3 of the population in prison today in India, okay, is of under trials. Okay, 2/3 of the population is under trials. So they are not tried; they are in jail for large number of years. Okay, and most of them, overwhelming majority of them, are either tribals, Dalits, Muslims, and in any event, poor people. Rich people will somehow manage to get out on bails and do something or the other. But these are the kind of people who are in jail. Some of them are in jail because of UAPA, that is the anti-terror law. Some of them might be in jail because of PMLA, some because of sedition, some because of hate speech. I mean, what happens even in hate speech, as it was explained earlier, that you give a hate speech, okay, somebody gives a hate speech against Muslims, that person is released on bail in a minute. But somebody gives a tweet about 4 years back, okay, that person is put behind bars in 5-6 cases. So you have a situation whereby not getting bail is something which the poor face on a daily basis. Okay? It's a very anti-poor justice delivery system. That's what has happened. And what hope they have, of course, they keep on fighting, they keep on coming out on bail from time to time, trying to go to lawyers who are willing to help them. So that is happening. It's not a totally hopeless situation. I wouldn't put it that way, but people are facing real wrath of the state by being in prison for a large number of years for a case which has not even been concluded against them, for which they are not even been convicted.
Thank you so much for that answer. I'll move on to our next question, which hopefully Mr. Desai, I think I'll pose to you. In the Mumbai train blast case, 12 people have been convicted but say they are innocent. Only one was acquitted, Abdul Wahid Sheikh, who has also written a book. 5 of those convicted have been sentenced to death. Would you be able to comment on this case and on the topic of the courts not recognizing when evidences are fabricated?
Well, fabrication of evidence has happened very clearly, according to me, in the Bhima Koregaon case, where about 16 activists from across the country have been put behind bars. I am representing some of those activists and we have been able to show by actually examining the computer disks, okay, by getting them examined by internationally reputed experts, okay, that the letters, because the entire case, as far as Bhima Koregaon case is concerned, is based on letters found on computers, not emails, mind you, okay, screenshots of letters, okay, found on computer. That's what the entire case is based on. And we have been able to show that these letters have been planted. And the person who owns the computer doesn't even know that they exist. We have been able to show that. But so up till now, what used to happen was hacking. Okay, that somebody hacks your phone, listens to your conversation, etc., etc., or somebody hacks into your email and sees what emails you have. But this has gone a step forward. That it's not just hacking; it's planting of evidence. Okay. Unfortunately, the courts are yet to hear this matter. It should be heard in the next couple of months, at least. That's what I hope. But this is about the Bhima Koregaon case. As far as the first case is concerned, the bomb blast case is concerned, what you're saying is right. In fact, I am representing 1 or 2 people in that case also. And and Vahid is a friend of mine. I mean, the one who was acquitted and who has written a book. Okay. And from whatever I can make out, okay, the evidence against them is very, 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 very thin. Okay, very thin, very slim evidence. Well, what happens is that you have a bomb blast somewhere. Okay, obviously you condemn a bomb blast. You're not going to say that you support the bomb blast. You condemn. That's fine. But then immediately police get into action. There is pressure on them that you arrest somebody. So they'll arrest some usual suspects whom they think are, might be involved. And they charge them with this. They torture them, then get some confessions made out of them. And the case goes on, And this happens not just with the Bombay bomb blast case. It happens with a number of cases. I wouldn't say all cases, but number of cases this happens, that people are picked up not because they are involved in the crime. A crime may have been committed. And obviously the people should be punished. I'm not saying no to that. But what I'm saying is that people are picked up without any evidence. And just now it so happened in Chhattisgarh. Okay. 121 tribals, okay, who were charged with killing some policemen and who were in jail for 5 years. All of them have been acquitted after 5 years. All of them, each one of the 121. But what happens? For 5 years they were in jail. Okay, it was never proved that they were guilty, but they spent 5 years in jail. And now they are out. Their lives are spoiled. And the police, and you will prosecute Himanshu Kumar and Tista, Setovad, but you are not going to prosecute the policemen who investigated those cases and put people behind bars for 5 years. The Supreme Court should be doing that, spending its time in doing that rather than prosecuting Himanshu Kumar and Tista, Setovad. That's all.
Thank you again for that answer. Really appreciate the detail you go into. I think we have time for one more question. This was, again, going back to what both of you have touched upon, but what is the pathway for human rights defenders such as Tista, Setovad, Arbi, Srikumar, and Sanjay Putz to be freed? I know we've seen some international condemnation, especially in the case of Tista, but what is the pathway for them going forward?
Himanshu, you want to answer? Himanshu, would you like to answer? See, on the basis of the present allegations which are against, see, Sanjeev Bhatt was already in jail, convicted of an offense, and has been sentenced to life imprisonment. Okay, his appeal is pending in High Court. So whether he gets bail here or not, it doesn't really make a difference as far as his incarceration is concerned. Srikumar and Tista, on the basis of the allegations which are made up till now, should have got bail on the very first day. And on the basis of the evidence which the police have been able to, show, they should have been given bail on the very first day. Now, unfortunately, that has not happened. But we are fighting, and we are hopeful that both of them will come out reasonably soon. We are hopeful of that. We don't know. Tomorrow there might be another charge sheet filed, another case filed. We don't know all that. But on the basis of the existing case, we feel they should be out. When I say soon, please understand, I'm talking in the Indian context. Okay.
Thank you so much. I appreciate both of your time today. I don't want to go too far over time, so I think we'll end the Q&A session there. So that's all we have in today's webinar. Once again, a huge thank you to our panelists, every one of you, for joining us today. And thank you for all the incredible work that you are doing on the ground in India. Our support and our thanks go out to both of you. This briefing was brought to you today by Genocide Watch, World Without Genocide, Indian American Muslim Council, Hindus for Human Rights, International Christian Concern, Jubilee Campaign, 21 Wilberforce, Dalit Solidarity Forum, New York State Council of Churches, Federation of Indian American Christian Organizations of North America, India Civil Watch International, Center for Pluralism, International Commission for Dalit Rights, American Muslim Institution, Students Against Hindutva Ideology, International Society for Peace and Justice, the Humanism Project, and Association of Indian Muslims of America. Thank you to our audience for tuning in. Thank you once more to our amazing panelists, and we will see you next time.